Hi, my name is Ahmed Abdi. I'm a business engagement specialist with the Seattle Office of Labor Standard. I'm also here with Jasmine Marwa, who will be co-presenting the webinar for Grocery Employees Hazard Pay Ordinance. This webinar is for information purpose only, and it's not for the purpose of providing legal advice, creating an agency decision, or establishing an attorney-client relationship between the Office of Labor Standard and the recipient. If you need legal advice, please consult an attorney. The objective of this webinar is to briefly provide an overview of the context for OLS and grocery employee hazard pay. And number two is to clarify who is covered under the grocery employee hazard pay. And number three, highlight the provisions of the ordinance. And now I'm going to talk about the Seattle Office of Labor Standard. The city passed the first labor law in 2011. Thereafter created the Office of Labor Standard and mandated to implement and enforce the city's labor standards. The Seattle Office of Labor Standards mission is to advance workplace equity. As you can see, there are 16 labor standards in Seattle. Even though some of them are temporary, but most of them are permanent. Starting from paid sick and safe time, known as PSST, fair chance employment, minimum wage, wage theft, secure scheduling, domestic workers, commuter benefit, hotel employee safety protection, protecting hotel employee from injury, improving access to medical care for hotel employees job retention, TNC driver deactivation rights, TNC minimum compensation, gig workers paid sick and safe time, gig workers premium pay, and grocery employee hazard pay, which we are going to focus today.
Thanks, Ahmed. So what is this new law? The Grocery Employee Hazard Pay Ordinance requires certain grocery businesses in Seattle to pay hazard pay of $4 per hour to employees who perform work at a retail store during the COVID-19 civil emergency. The hazard pay requirement is in effect from 12:01 a.m. on February 3, 2021, until the end of the COVID-19 civil emergency. The ordinance as a whole expires 3 years after the end of the civil emergency to allow for enforcement. That means that OLS may investigate potential violations of the ordinance up until 3 years following the end of the civil emergency, and covered employers must also retain records for 3 years following the end of the civil emergency. So who did this law apply to? Well, the law applies to grocery businesses with more than 500 employees worldwide. Grocery businesses are retail stores that are either over 10,000 square feet in size and primarily engaged in retailing groceries, or they're over 85,000 square feet with 30% or more of its sales floor area dedicated to the sale of groceries. And groceries includes, but is not limited to, fresh produce, meats, poultry, fish, deli products, dairy products, canned and frozen foods, dry foods, beverages, baked foods, and/or prepared foods. Who is not covered? Well, convenience stores selling a limited line of goods, farmers markets, and businesses with less than 500 employees worldwide are not covered. What about the cases that are not as clear, such as when a large store sells groceries as well as many other items? How will OLS determine what is a grocery business? OLS may consider any number of factors to determine whether a store is primarily engaged in retailing groceries, looking at the facts of each case. The factors OLS may consider include, but are not limited to, grocery sales as a percentage of the retail store's overall sales, sales floor area dedicated to the grocery sales, marketing or promotional materials from the employer, or other public statements from representatives of the employer. In an investigation, OLS will make a reasonable determination as to whether a business is covered by the ordinance, and the employer bears the burden of proof to show that they are not in fact covered by the ordinance. Which employees in a grocery business are owed hazard pay? This law applies to employees who perform work for a covered grocery business at a retail location in Seattle, who are also covered by Seattle's minimum wage ordinance. Who is not covered by the ordinance? Well, those who are not covered by the minimum wage ordinance are not covered. Gig workers who receive gig worker premium pay or gig worker PSST for the same work are not covered. And in addition, when we're looking at who performs work for a covered business at a retail location, OLS may consider any number of factors, including but not limited to the proportion of an employee's typical shift spent at a retail location, the nature of the work performed, or the degree of contact with the general public and other grocery employees during the course of their work. So employees who do not spend a significant amount of time in a retail store and have limited interaction with the public or other employees would not be covered. Covered employees for a covered grocery business must receive at least $4 per hour in hazard pay. Hazard pay is in addition to compensation, bonuses, commissions, and tips owed to a grocery employee for services provided. Grocery businesses are prohibited from taking steps to reduce other employee compensation because of this ordinance. Employers must maintain records to establish the reason for any reduction in employee compensation. Other things to note about this ordinance is that hazard pay must be paid at the same time that compensation is normally provided for the hours worked. Hazard pay must be separately itemized from other compensation on paychecks. Grocery businesses must issue their employees an updated Notice of Employment Information as required by Seattle's wage theft ordinance. And for purposes of compensating an employee for paid sick and safe time, hazard pay is considered a premium rate and is not included in the employee's normal hourly compensation. So PSST is paid out at their base rate.
Thank you, Jasmine. Now I'm going to talk about notice, posting, and records. All employers are required to post the notice of rights posters in English and the primary language of employees at the store by March 5th, 2021. Employers are also required to keep records up to 3 years that shows compliance with the ordinance. As you may already know, retaliation is illegal. An adverse action is some action that negatively impacts any aspect of employment, including pay, work hours, responsibilities, or other material change in the terms of conditions of employment. Here are some examples: denying a job or promotion, demoting, terminating, failing to rehire after a seasonal interruption of work, threatening, penalizing, engaging in unlawful immigration-related practice, filing of a false report with a government agency, changing employment status, unlawfully discriminating against an employee. These actions are considered illegal when taken against employees. I would like to provide you with some key resources about grocery employee hazard pay. Please visit the Labor Standards Grocery Employee Hazard Pay webpage to learn more about the ordinance. You can also find the ordinance language that will not be codified, similar to other COVID protections. You can also find the fact sheet translated into Amharic, simplified Chinese, Somali, Spanish, and Tagalog. Other key resources is a grocery employee hazard pay question and answer document, also known as Q&A. There are 3 ways you can contact our office if you have questions about hiring entities. For technical assist, please call the number 206-256-5297 or contact us through laborstandards@seattle.gov or business.laborstandard@seattle.gov. You can as well send us a message through our online inquiry form. Thank you.